morning. This is a status conference in docket 8571, petition of Swanton Wind LLC for approval of a Rule 4.100 power purchase agreement. My name is John Potter. I've been appointed hearing officer in this proceeding. With me today is Greg Faber, and also working with Greg and I on this matter will be Mary Jo Kolewski, but she was unable to attend today. So let's start out by taking appearances, starting with the department.
Aaron Kosicki on behalf of the Department of Public Service, and with me is Tim Duggan. I'd like to note that Mr. Duggan is the counsel of record right now. There's going to be a substitution of counsel to me that hasn't been filed yet, but it will be very shortly.
Okay.
James Gibbons from Burlington Electric Department, Director of Policy and Planning. Mr. Ellis is unable to attend today because of medical treatment.
Okay.
No.
Am I up?
Nope. Yeah.
Sure.
Leslie Cadwell, Legal Counselors and Advocates, PLC, on behalf of Swanton Wind, the petitioner.
Mr. Cotter, I'm Bernie Lambeck. I represent VIPSA, and with me is Melissa Bailey from VIPSA.
Is that L-A-M-B?
B-E-K. L-A-M-B-E-K. Thank you very much.
Hi, Cindy Hill for Hill Attorney PLLC, and I represent interveners Christine and Dustin Lang in the Swanton Wind 248 case, docket 8816. With me today are several other neighbors who have interventions pending in that, and our interest here is relative to the how this relates to the scheduling and of that case, or what's going to how those cases are going to relate to one another.
Right. Well, we won't be discussing the scheduling of docket 8816 today. It may come up, but we're not going to be doing any setting of dates. The board has received people's proposals, and we'll be issuing a scheduling order shortly.
I understand.
So that's everybody. We're a status conference to try and come to some decision about how to move this matter forward. I know that the department had represented that it anticipated renewing a motion to dismiss this particular proceeding, and yesterday we received a motion to dismiss from Green Mountain Power Corporation, and I believe that the letter that accompanied that motion indicated that Vermont Electric Cooperative Inc. and the Burlington Electric Department were joining in support of Green Mountain Power's motion. So we certainly need to set a response date for the Green Mountain Power motion and potentially a reply to any response that gets filed, and hear from the department on what it anticipates in terms of renewing or filing a motion to dismiss and setting some response and reply dates to that. So why don't we start, since Green Mountain Power has already filed its motion, why don't we go ahead and talk about response and reply dates for that. Obviously, the Vermont Rules of Civil Procedure would provide for a 15-day period to respond to GMP's motion, and then 10 days after any response is filed for people to file replies. Do we want to just go with the civil procedure dates for that? Ms. Cadwell, why don't you go ahead and start, since you're not here?
Yes. Just a clarification. Was this, I wasn't included in the electronic distribution of the GMP motion. I just found out about it right before the status conference. And the cover letter said it was hand-delivered on the 8th. I think you just said it was filed yesterday, the 9th.
Oh, I'm sorry. I'm getting my dates confused. Yes, it was filed. Yeah, it was filed here on the 8th.
Okay. I know it doesn't make that much of a difference. It's a difference of a day. I would prefer to have an idea of what the procedural schedule is in 8816 before addressing scheduling in this matter. I have some commitments. I'm going to be away out of the country for a week in December, early December. and then again in late December. So if there is, if we could accommodate, what I would prefer to do is bump a response to this until after the first of the year. The case has been pending for a while, and without the benefit of knowing what the 8816 schedule is, given my co-counsel's now out on maternity leave, I've got some scheduling issues, and I would really benefit from having the knowing where 8816 is. This proceeding doesn't need to move on a fast track. It's been pending for a while.
Any responses?
I think adhering to the scheduling that the rules of civil procedure outlines is preferable to the department. As the department lined up in 8816, we would like to have this issue in docket 8571 resolved with respect to the pending motion for dismissal prior to any discovery that occurs at 8816. I think if we were to adopt the rules of civil procedure scheduling, that would get us response dates before, at the latest, the 2nd of December or so, which I think would accommodate Ms. Cadwell's absence. So I think that's the way to go. And I think I might be getting ahead of myself here, but I don't think that the department would necessarily need to file an independent motion for dismissal, given what GMP has filed already. It very well may be that the department, in filing a response here and then another reply, we would be able to play our position out sufficiently without having to file an independent motion.
So just so I'm clear, you would be potentially anticipating responding to GMP's motion as opposed to filing an independent motion?
Correct.
So you would be filing 15 days out from the filing date of GMP's motion?
Correct.
Okay. Mr. Gibbons?
We would certainly prefer the shorter timeline as well.
Okay. Mr. Lambeck?
Yeah, no, we're easy about this, either way.
Okay. Ms. Cadwell, when is it that you're going to be out of the country?
So I'm going to be leaving after the 15-day response time. The challenge is that I have other demands on my time before that, and adding a response to this is really a burden. If I don't have a choice, obviously, we'll do our best to respond within the 15-day time period. I did not understand the board's order putting this docket on stay as inviting renewed motions to dismiss. The board's order said that once the Section 248 petition was filed, it would proceed with its review of the petition as well as a requested approval of the 4100 contract. So I was surprised to hear that there were going to be renewed motions to dismiss in light of the board's order, and would just request some accommodation in light of the fact that there's really, I'm not sure I understand what the need for turnaround on a motion in this docket. I'm not sure what it accomplishes.
Well, I guess, correct me if I'm wrong, Mr. Kosicki, but my impression, Ms. Cadwell, was that the department wanted an opportunity to renew its motion to dismiss in this matter, and if that motion were granted, that may indeed impact the companion docket, or if that motion is denied, then perhaps at that point would be where the board would consider both dockets coincidentally. Which, kind of makes sense to me, to be honest with you.
And Mr. Cutter, if I may, the department's sensitive to Ms. Catmull's scheduling constraints. To that end, we're open to being flexible with pushing these dates out as need be to accommodate your scheduling. But I would just say that we're also very cognizant of how pushing those dates out may impact the scheduling that we're asking for in 8816. The board is aware of our concern of the sequencing of these two issues. So with that in mind, I would say we're certainly not wedded to a short turnaround time on the responses here, but we'd like to be able to still ensure there's enough time to resolve this motion to dismiss prior to any meaningful discovery being conducted in 8816.
So,
May I respond?
yes, of course.
Yeah, thanks. Even assuming this case, the 8571 were to be dismissed, I still struggle with understanding what impact that has on the Section 248 proceeding. We have the PPA itself is only a part of the filing. The 248, we're not asking or relying on the in the 248 proceeding, we're not relying on the PPA request. We've put in a case that explains that the need for renewable energy that the project will produce arises from the need for renewable energy in New England. And there are a variety of ways to accomplish that. We've presented a couple of different ones. So even if this proceeding were to get dismissed, I don't see how that bears on the 248 as I indicated in 8816. In any event, if the hearing officer and the parties really believe that it's important to get this done before Thanksgiving, or at least the response before Thanksgiving, I'll go ahead. We will meet the deadline. But I don't see the connection between the two dockets other than the project will have to satisfy, according to the board's rule, the project will have to satisfy the 248 criteria in order for the board to approve the contract in this case. So this case can just hang there until the other case is done, and we can revisit the issues in this case at a later time. And depending on where things develop in the 248, for example, if the contract with the folks in Connecticut through the RFP, which Swanton Wind was awarded the ability to negotiate that contract, if that comes to fruition, it basically moves this case. So my preference would be to leave this open and let the 248 play out.
Any responses? Yes, Mr. Gibbons?
This is James Gibbons from Burlington Electric Department. This is one of a number of motions to dismiss. From Burlington Electric's point of view, it is unclear whether we're going to be getting this power or not, depending on which version of the rule it's treated under. We may be making other resource acquisitions. It would help us to have this cleared up in a reasonable amount of time. It's been sitting out there for some of these documents for over a year. And to understand whether they're going to be treated under the new rule, the old rule, at what rates, would be helpful for our planning.
Okay, thank you. Mr. Kosicki, any further?
If I may, Tim Duggan.
Yes.
I would just note that the board's order, excuse me, staying this proceeding was issued almost a year ago, December 11th, 2015. It was in that order that the board allowed for a reasonable opportunity for Swanton to cure the defect. And I think there would be a concern about leaving this open in the way expressed by Ms. Cadwell, because it seems it's being left open kind of on an open-ended basis, and that does not seem to be consistent either with the order staying the proceeding or with the fact that there is now a new Rule 4100 in effect. So, moving, with reasonable diligence to wrap this up is, I think, appropriate.
Okay. Mr. Lambeck, any comments?
No, thank you.
Okay, here's what we're gonna do, and this, Ms. Cadwell, I'm gonna thank you for, stepping up to the plate on this one. I understand that you're very busy, but given that the response time would be prior to the time that you'll be out of the country, I think we're just gonna go with the, Vermont Rules of Civil Procedure, which would provide for 15 days to file a response to the Green Mountain Power motion, and 10 days after that for anybody to file any replies to the responses. I do tend to agree that at least with the posture of this case, I'm not on any of the other cases that the motion to dismiss applies to, but I think that there could be some value in attempting to resolve this issue as the new Rule 4.100 takes effect, so that it would be helpful to resolve it sooner rather than later. So we're just going to go with the standard response times. I look forward to reading everybody's submissions. Is there anything else we need to discuss?
Just in terms of what that means in terms of the response time, sometimes there's confusion about the 3-day mail rule. So I guess I would request that you set a date that includes the 3 days for mailing.
Yeah, okay. So 15 days plus the 3 days for mailing.
Awesome, thank you.
Okay, thank you very much, everybody. We're adjourned.
Thank you.